the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Welcome back to Case Files. I'm Jonathan Sarr, Property Management Education Specialist, joined by Leslie Tucker, a fair housing attorney and national trainer. She rocks. Today's episode is a bit of a cautionary tale regarding a shift we're seeing in the legal landscape.
Yeah, that's right, Jonathan. We're moving away from the idea that only government agencies like the Department of Justice bring these types of suits. We are seeing private citizens acting almost like independent, secret shoppers, launching these massive waves of litigation all on their own.
So today we're reviewing the recent LA real estate alert regarding Alexis Watson and her lawyer, Alexander Robinson. And this isn't just about one mistake. It's about a new type of litigation strategy that property managers need to recognize immediately.
Yeah, generally, property managers in the past have looked out for testers from fair housing organizations. And of course, that is still happening. That is still going on nationwide. But in this particular LA case, we see a private citizen using platforms like Zillow to screen landlords. If she gets a text response that happens to violate California's source of income laws, she files a lawsuit.
Okay. And Leslie, she's asking for $100,000 per suit. So for a small mom and pop landlord or a single real estate agent, that is a life-changing amount of money.
It is. And because these are private suits, they can move fast. Defendants are often settling for, 5 figures just to make the case go away, because defending a full civil case all the way to trial, will certainly cost much more than that.
Yeah, absolutely. So it sounds like it's quite the racket for sure. So the plaintiff believes that they know the law inside and out, likely better than the person answering the text message, and they're looking for that one smoking gun response like, the owner doesn't participate in Section 8. So why is the property management community such an easy target for this right now?
I think it has something to do with kind of the interest in doing business quickly, the speed of business, if you will. We're all communicating, via text and app-based messaging, and it feels informal. So sometimes staff might drop their guard. They might type a quick, no, or not at this time, without realizing that they may have just given the tester exactly what they're looking for.
That's crazy. So many managers, they still rely on what the owner provides, instructions. So if an owner tells an agent, I don't want the hassle of Section 8, and the agent relays that to the tenant, the resident, the agent and the brokerage are both getting sued.
Yeah, absolutely. In these private suits, the plaintiff generally is going to name everyone involved, and that would be the agent, the broker, and the owner. You can't hide behind, the I was just doing what the owner told me to do defense.
Got it. Okay. All right. So for our audience, I'm the property manager. How do I protect my team from a private citizen launching these types of suits?
Well, it's important that you treat every single inquiry, even a text message that comes in at 10 p.m., as a formal legal interaction. It's so important that you know the law in your state or locality, because many of them, like California in this case, have adopted fair housing laws that protect on the basis of source of income. So if your property is located in one of those areas, never say no to a voucher inquiry. It's a good idea to use a script instead that says something like, we accept all legal sources of income and we look forward to reviewing your application, right? Something very safe and generic. And, if you are working with homeowners, it's important that you tell them that, you work, in a state that protects people based on their voucher holder status. So in California or another state that protects this, you need to make sure to educate your homeowners of this fact. And it's refusing Section 8 vouchers is illegal.
All right. Some great tips. Thank you, Leslie. And remember that these private plaintiffs aren't looking for bad people, so to speak. So they're just looking for compliance errors. One agent was sued simply for saying the house might be too old or too old to pass a Section 8 inspection. So that's an opinion that cost them a fortune. So the landscape has changed. It's a different world we're living in. We're in an era where any private citizen with a smartphone can become a self-appointed fair housing enforcer. So Leslie, what are some quick takeaways you can share with our community?
So whether you agree with the plaintiff's tactics or not, I know I have my own opinions about that, and I'm sure you do too. But regardless, the law is clear. Source of income discrimination is a violation of the California fair housing law and in many other states as well. Your best course of action is to remember a few things. Private suits can and are a new reality. You're not just waiting for the government to catch you making a mistake. You're being watched by opportunistic members of the public. Remember that text messages can certainly be used in a lawsuit, and they are all the time. And ignorance is not a defense. Okay, I didn't know the law isn't a defense and certainly is not going to stop a lawsuit. So good things to keep in mind.
Yeah, thank you very much. Great takeaways for our audience. So thank you so much for breaking that down. And a special thank you to our wonderful community for following and sharing your thoughts with us. We appreciate you being on this or listening to the show, whether it's on YouTube or on a podcast. This concludes Case Files. We'll see you next time. Take care, everyone.